But, you know, I got to tell you this. It was real easy for me to prepare to give this talk today. Not because Kelly did my PowerPoint, or not because, you know, all I had to do was just read this, show up here and read this, or talk to you guys. But the stuff we're going to look at has come across my desk since the 1st of December. I kid you not. This is real life stuff that has come across Bob Burns' desk at my law firm since December 1st. So I have dealt with this, I have counseled on it, I have reacted to it, I have, in some cases, mediated or arbitrated, all kinds of stuff. It happens all the time. Learning objectives for you all. What are your learning objectives? My suggestions are, number one, let's all have some fun. You all work hard all the time. We work hard for you, for many of you, and that's a privilege. But let's have some fun with this because it is fun. Number two, let's try to sharpen your awareness that when you look at a contract, something goes up, a red flag goes up or a signal goes off in your brain and said, hey, that is a stupid contract clause. And you might not be the one to solve it, or you might not be the one to fix it, or you might not even be the one to say yay or nay, we're going to do that or we won't do that, but at least you'll see it and you flag it for somebody who might help you either fix it or make that decision. Thirdly, we'll talk about enough specifics of a few areas because of the examples since December 1st that I picked to talk to you about today as illustrations, that maybe you'll learn a little bit more about a few selected legal areas that will benefit you overall. So I would suggest have fun, heighten your sense of awareness, and learn a little bit. So off we go. Any questions so far? Okay, that's it. Nothing further. Class dismissed.
Check, see if it's turned on or not. Maybe on the back side. There is no.
Are there any?
Oh, wait.
Side
Oh,
There you go.
yeah.
The key does, the car does run better when you insert key first.
Technology experts.
Yes. Now you know why I'm not teaching IT 101. Okay. Okay, that's me. All right. Here's just some of the things. This is just kind of an overview as to what we're going to go into. What are some of the pitfalls? Why are we doing this? Okay. First of all, you're going to see language today where if signed as is, or if agreed to as is for one of the parties, it just could produce a flat, terrible result. It says something like, thou shalt do something, or thou shalt not do something, or whatever it says. You'll see when we get into them, just bad language. There's no mistaking what it says. It's just awful. Why would you want to agree to that? The other thing you can get into, and we see a lot, is questions of ambiguity. Legally, there are rules where you sort out ambiguities, but who's looking at the language? First of all, you have the parties to the agreement. Is the owner reading it one way and the contractor reading it a different way, or the contractor and a sub? What about if it gets to a dispute level and you're into a situation where you have a arbitrator or a mediator, or heaven forbid, a judge, which has gotten to be my least preferred way to resolve disputes in construction, because judges are nice people, but they just don't know construction. And then you're asking a judge to interpret an unclear contract provision. Oh, scary. What about your business partners, like your bankers, your lenders, the surety, those kind of folks? They look at your agreements and they're going to read them, and they're going to take their interpretation. Is that the same as yours? And so the dangers of bad contract language are just replete throughout the whole situation. And then we're going to see a great example, and I've seen a scary amount of this, where there's contracts that just contain whole sections or whole clauses or whole provisions that just don't apply to a construction project. They just don't apply. Well, okay, it's easy enough to say, well, NA, it doesn't apply. Who cares? Just leave it alone. It'll never come up. Well, you'd be surprised. And when it comes up, if you have a judge or an arbitrator who's looking at a contract, you know what they say. I would say it if I was a judge or an arbitrator. Hey, this is the contract. I've got to try to make some meaning out of this. I can't just ignore it. I mean, these people signed it, so it's a contract. So I have to pay some attention to it. And and if it's relevant to the dispute, I have to try to understand what it's trying to convey. First one, we're going to look at real language. I'm going to give you all a few minutes to read it. Everybody see it?
I got a bridge for you, Mike.
We've got some swampland in south of Louisiana. This language is in a contract between a sophisticated owner and a sophisticated contractor, not people that just fell off the turnip truck. This language was drafted by a lawyer who I know well, and I respect, and I like, and we're friends, personally and professionally. And I've talked to him about this language, and I've said, Jim, picking on Renner, that's not really Renner, but Jim, do you really think that language is going to hold up? Anybody want to venture a guess what his answer to me has been? Hell, I don't know. Okay, now, I'm not on the other side of the language, so I kind of don't have a dog in the fight directly on this particular matter. But this language is very instructive in terms of, okay, is there any contractor in this room, whether you're a GC, a construction manager, a sub, or whatever you are or have been, that would just willingly and happily sign up to that? Okay, I guess by the lack of show of hands, no show of hands, that means you wouldn't. How come? Why wouldn't you sign up to that? Anybody want to venture a first swash with the sword?
Because you're waiving all claims against any additional compensation unless you have a written statement.
And not only that, it's got a pretty, I'll tell you, and this is now more my world than it is y'all's, but it's got a pretty all-encompassing laundry list of legal causes of action. I mean, there's not a whole lot more left in the legal arena or legal world of claims and causes of action that the lawyers can articulate to try to pull a rabbit out of the hat on this deal. Okay, well, what are some of the obvious, or maybe not so obvious, legal risks that I saw in this deal? First of all, try that again. Okay. What is work properly completed under the contract? That is always a Pandora's box in construction, as far as I see it. Okay, you have the scope that's usually attached or incorporated or referenced by pulling in the plans and specifications or whatever, so you know your scope of work. But is that scope clear? What about change orders? What about if the work is changed either actually or constructively, and the owner says, I ain't giving you a change order for that. But you did the work anyway, okay? Legally, I tell you the law does not favor releases in advance of a claim coming into being or being created. In other words, I can't, it's difficult for me to release something that I don't even know exists yet. And to me, the language, based on work properly completed under this contract. Well, at the day I signed this contract, I haven't completed a lick of work at that point in time. So I don't know where the hell this is going, you know? And so if it gets to be in the situation where there's more work done down the road that I should get a change order for, but the owner doesn't want to give me one, what is it? I can't sue him because I just haven't waived my rights. Well, legally I can tell you there's a real legal issue there. And that's why I think my fellow lawyer, when I asked him about what he thinks of his clause, it was kind of like, well, we're going to try, but we don't know if it'll hold up. Another very interesting question to me is, does all that laundry list of stuff that's gone, that you can't do, even though you didn't know about, you're going to have, does it release your right to file a mechanics lien? Because the Kansas Fairness in Private Construction Contract Act clearly says a provision in a contract which purports to release the right to file or waive the right to file a mechanics lien is void and unenforceable and cannot be waived by the parties to a private contract. So if I was to be in a position where I was needing to attack this clause, I would probably go there because I think that's a direct statutory reference that I could probably set a hook in the fish, hopefully. How I would defend against that, I'm not sure. And maybe the most important, maybe not the most important exclusively, but an incredibly important consideration, how much do you want to spend litigating, arguing to that judge who doesn't know much about construction law, whether this should be enforced or should not be? You want to go through a trial? You want to go through an entire trial? You want to spend a couple $100,000 or more finding out who was right? Not a good business proposition. So the risks of signing up to this kind of provision, to me, are just legion. They're just horrible. Any thoughts, questions on?
Yeah, so that's a pretty extreme example with lots of legal terms in there.
Yes, sir.
You see limitation of liability conditions that are much less onerous, maybe, that just say, hey, we're going to limit the amount that we pay on a claim
Absolutely.
to the cost of your contract. How enforceable are those?
You know, I just have looked at that, and where those usually come up or have come up in my world is in the world where an architect or engineer, a design professional, wants to have an LOL, limitation of liability clause, and the law is pretty uniform and it's pretty consistent that if those limitations of liability clauses are properly drafted and they're clear, they're enforceable. Usually it is a limitation as to the amount of fees that were billed by the professional, or any insurance that is properly recoverable by the professional, or some selected dollar amount, 100,000, 250, 500, whatever. But that's a good question, and the distinction I would draw on what you're asking is you're asking about a limitation of liability. This is an exclusion of liability. Limitations are somewhat reluctantly, but they are still upheld. Exclusions are very disfavorable. Good question. Additional thoughts? Okay. Bad, bad, bad. You don't even have to call me. I'll tell you, don't sign it. Don't sign it. Damages. I get these questions a lot. And it always comes out of a liquidated damage provision. But let's just read this first. There's more after this, so give me a nod when you're done with this page, or just this slide, or a hand. And I apologize. I was one page ahead of myself. There's not one. This is the language we're going to talk about. Everybody read it? Everybody seen this? Read it? Okay. All right. Is there a contractor in a room that would sign up to this deal? Okay. Got your answer. How come? Why wouldn't you sign up?
It doesn't limit you to $100,000, it limits you to all other costs the owner may incur on top of it.
Okay, I read it a little differently. I read that their exclusive remedy is $100,000 a day. And it waives everything else. But I guess let me rephrase my question just to make sure we're reading off the same sheet of the same slide of the PowerPoint. Is there a contractor in this room who would sign up to a potential liquidated damage contract amount of $100,000 a day? How come? Too much, right? Okay. Is there, show of hands, how many people in the room would say, first I'll give you the choices of answers and then you can vote. The answers are going to be enforceable 100% of the time. Second answer is never enforceable, that's ridiculous. Now we're talking about enforceable, even if you sign it. Third answer is, hell, I don't know, it depends. Answer one, enforceable every time. Show of hands. Who says it's enforceable? Kurt? Okay. Oh, college man, sorry. I won't embarrass you. Okay. Who says it's not enforceable? Okay. Nobody says it's not enforceable. Okay. Who says, hell no, I'm not sure if it's might be or might not be? Who says that? Okay. Anybody want to tell me why? Just raise your hand on answer 3. By the way, that's the right answer.
Because it does depend.
Okay, what does it depend?
It depends on the enforcement of, well, the application of substantial completion and everything that goes with that in this case.
When, for example, when substantial completion
Right.
occurred? Okay. All right. Let's.
Plus the owner's on
Let's
how
say
they
who's at
keep it.
fault for not
Right.
reaching substantial completion.
Okay. So it doesn't say who's at fault. Okay.
It depends on how they come up with a $100,000 number and whether they can justify that as a reasonable liquidated damage.
Okay. Let's hold on to that thought.
Is it a reasonable liquidated damage if it's the new Vegas Stadium for $1.7 billion?
Okay. Let's
I was
hold on
going
to
to say,
that
the
thought.
Mercedes-Benz, that's very,
Okay. Okay. I like the answers that are coming out here at the end. Let's look at some of the rules now with respect to contract damages. And here's the thing we got to do. This is one of those things I said, we're trying to learn some about some little specific areas of the law that will help you after you leave. This is one. We're going to look at the rules on damages, period, not just liquidated damages, because you got to understand all of them to really make sense of what the correct answer is here. And Jason and, sorry, your name? Jared, you guys are on the right track. But here's how I think we get there. First rule. An aggrieved party, somebody that's been injured by a breach of contract. This is the law. Doesn't have to say this in the contract. This is the law says. Can only get actual damages or liquidated damages. You do not get both. Okay? Only one or the other. Okay? So if you have an LD clause in your contract, setting aside how much it is, how it's written, all that, if you have a liquidated damages provision in your contract, actual damages are pretty much out of the picture at that point. Okay? But now let's talk about actual damages as the backdrop to going into what liquidated damages are and how they work. First of all, there's many forms of actual damages. Direct damages, indirect damages, consequential, incidental. We're talking about if there's a breach of contract and somebody doesn't install the furnace correctly and the wiring shorts out, well, probably furnace got burned up in the fire and have to be a new furnace because the furnace that was installed, nothing wrong with it, the wiring though shorted out and caused the fire that burned up the furnace. So that's a direct damage. An indirect damage might be as a result of that fire, there's a whole bunch of smoke in the mechanical room. And maybe it got so bad, maybe the heat got so bad that some of the water piping, or whatever, I'm just making stuff up, was damaged and the water piping will have to be replaced, or just the soot and the damage exposure that would result naturally from the smoke of the fire. Indirect damage. Incidental and consequential, kind of a fine line between the two. But as a result of this fire, they had to shut down the plant for 2 weeks, and they lost revenue of $100,000 per day because they couldn't operate the plant. That's an incidental, or probably more in that specific instance, of consequential damages. Those are actual damages. Now, here's a question that I have been asked lots of times. Well, we don't have to worry about damages. There's not an actual damage clause in the contract. Wrong. That's not correct. Actual damages are supplied as a matter of law. You do not have to have a clause in your contract to say you get actual damages. Flip it. We'll see in a minute. You do have to have a clause to get liquidated damages, thereby contract or agreement. If you breach a contract, or if a party breaches a contract, and there is a showing of breach and a showing of damages, whatever kind they are, the furnace, the wiring, the smoke, the whatever, the downtime, and it can be proved, those are actual damages, and you don't have to have a contract that says, I get those things if that sort of thing happens.
But if you have a liquidated damage provision, you've given up the right for actual damages?
The aggrieved party has. Well, now, if the damages in question are a time-related thing, I was using the furnace and the fire as just an illustration of damages per se, more broadly stated. The time element of damage, not getting the job done at by a specific date, that can either be the subject of actual damages or liquidated damages, but not both. I don't know if I answered your question.
So Bob, question.
Yes.
The LDs or actual damages are related to the prosecution of work.
Right.
If the contractor or subcontractor caused a fire, that could be outside of the scope of the agreement.
Correct.
With regards to actual consequential
Yeah,
damages,
that's
unrelated to LDs, right?
The fire is probably more of a property damage, or it's more
General
of what I call,
liability.
more of a PIPD, property damage, general liability policy coverage matter. Now, if as a result of all that property damage, the contract doesn't get done by a date required, then you could be talking, in addition, the late finish or late completion damages too. But
You can have both, right?
Oh, sure. I mean, they would be able, if there was a fire and somebody was at fault, and it also, and the fact of the fire also caused the job not to get finished by the required date, you would have both late completion damage and the person, and the
Actual.
and the actual PIPD damages as well. And the existence of a liquidated damages clause would not preclude you as an either insured or as an additional insured from making a claim under the policy. You'd still, now you, whether the liquidated damages would fall under that, that's a whole other can of worms. Probably not. I know people have tried.
So you're doing a $2 billion stadium project, $100,000 a day might be peanuts compared to what the
Might
actual
be.
damages are. But-
Absolutely.
But are you saying you would not be limited to just the 100,000? They can still come after you for actual?
No. If you were building one of the new NFL football stadiums and you had a liquidated damages clause for failure to complete the project by a required date, and the amount set forth in the clause was $100,000 per day for each and every day, that's your exclusive remedy for the late completion, not for the furnace that burns up in the men's room too. Yeah, no, you couldn't get, just to say it on the flip side, you couldn't get the $100,000 per day and actual damages as well. Now, here's the whole reason, my next point up here, it's the whole reason why people use liquidated damages clauses. It's because we're back to the same question that I asked at the end of the last exclusion of everything clause. Do you want to go to trial and have to put on your proof of your actual damages? An actual damage, I mean, if it's a complicated damages trial, you could be in the courtroom for 2 weeks. You want to go, and maybe or maybe not, probably not, getting your attorney's fees. So how much do you want to eat into your damage claim? So the reason liquidated damages clauses in construction are so generally popular and liked is because A, they make it pretty darn black and white. You're late, it's $1. 2 days late, $2. 3 days late, $3. I mean, it's just math. You don't have to prove up anything. You just get out the calculator and you just do the math. So we don't have to go to trial. We don't have to even usually establish a claim. There can always be, on either an actual damage or liquidated damage, late completion scenario. Yeah, should have given me the time extension, but you didn't. I was entitled to a time extension, whether extra work, whatever it was. Oh, well, I'm not going to give you that time extension. You remember that clause you signed in the contract that excluded you from everything? Strike through, you're out. But anyway, now let's talk about liquidated damages. We've kind of been focusing as a backdrop as to what the liquidated damages are by looking at the rules on actual damages. Now let's look at what liquidated is. The legal rule to enforceability, and there's a lot of latitude on this. I don't mean to say this is like the eye of a needle trying to get a camel to pass through it. But the legal rule is liquidated damages have to be calculated in an amount reasonably designed to approximate what the actual damages would have been had there not been a liquidated damage clause or an amount set forth in the contract. So now we're back to the NFL stadium question. A liquidated damage amount for failure to get a liquidated for failure to get an NFL stadium finished and ready for play is probably a whole different number than doing a grocery store or doing a convenience store or even a gas station or some retail establishment or even a hospital or a fire station.
Casino.
Yeah, casino is thought to be the hallmark of as bad as it could possibly get. Now, bringing up the casino is another good illustration because on the casino, can you only imagine if somebody's building a casino and they're late and there's no liquidated damages clause, can you imagine what the estimates are gonna be, what the actual damage is? Oh God, you aren't gonna get anybody in this place, this is a big sty and nobody gambles in this state anyway, and you know, you might have lost 10,000 bucks a day. Are you kidding? We would have had at least $1 million a day coming in here. And now you're fighting that in a trial. So that's another good illustration of why people in construction tend to like liquidated damage clauses, okay?
But you're saying legally, even if you sign up for something crazy, $50,000 a day on a $2 million job, you have a legal right as a contractor to
Contest it. Object to it.
really,
Absolutely. Now let's say.
even
well,
if you
listen-
sign the agreement.
Yes, sir. Yeah, the legal rule is the amount of liquidated damages must approximate what the actual damages would have been absent liquidated damage clause. They have to be somewhere in the ballpark. And there's latitude on it. That's not a tight, but now see, up here I have, if the amount's too small, don't worry about it. If the amount's too small, no, you know, if it's the owner's liquidated damage clause, which is probably going to be, the owner's not going to be able to go into court and say, well, I didn't put a big enough number in there. It should have not been 10,000 a day. It should have been 100,000 a day because this is a freaking NFL football stadium. Well, Mr. Owner, sorry, you got your chance. Now you're just trying to take an end run and seek to get actual damages when you have a liquidated damage clause, and we know the rule of law is you can only get one or the other, you can't get both. So King's X, you're out of that deal. So the amount too small, it's there, it's gonna stand. If the amount's too big, it's arguably unenforceable. Now, how many times have I actually advised the client, oh, just go ahead and sign it. That's so damn big, you don't have a thing to worry about. Yeah, Mike Haefling said I have some stupid clauses, but not that stupid.
And I forget the name of it, but does that also, is that impact like if the size of the owner, Walmart, and a smaller contractor, it doesn't,
No.
that you've got an unfair advantage or something with that?
I can't say it would never play into it at all. But if it did, it would play in at best indirectly, because the damages Walmart would suffer if their Sam's store, or well, if there's, you know, what were those little tiny kind of little retail? They were bigger than neighborhood shops. I mean, they were big. They weren't as big as a Sam's. Okay, if one of those doesn't open on time, there's arguably going to be damages. But if it's Sam's or Walmart building one of those versus the local grocer, the local guy that is the maybe not HEB. That's not a good example. But you know, somebody much smaller. The damages are the same.
Yeah, I didn't know if you have to sign this I thought there was something about kind of, I hate to use the term bullying, that if you want this contract, you're going to sign this for this much money.
Well, now that argument could go into, hey, this is just too big a number, it's unreasonable. It far exceeds the number that actual damages would have been, but for a liquidated damages clause. But in terms of Walmart doesn't need it, and this guy does, because he's little, zippo. If that's my best argument, I need to sit down and let somebody else go.
Does who drafted the contract play in? Like you're signing a contract drafted by the owner versus the sub is signing a contract that you drafted?
In certain instances, that can be a consideration. There are a number of contract provisions which you look at just at both parties' perspectives pretty evenly, and liquidated damages is probably one of those. So whether I drafted it and they agreed to it, or they drafted it and my guys agreed to it, we all agreed to it. So the rule still remains. It has to be a reasonable approximation of what the actual damages
I'm
were.
just thinking of the example you gave where the owner comes back and says, well, that wasn't big enough number. Well, you drafted the contract, you know, I mean,
Well, now, I'm not saying that it would be above me to make that argument, but that's probably not your deal. That's an open, oh, by the way,
Also, when some of the liquidated damages get to those extreme amounts, I've also read that if it's offset by a opportunity for a bonus, so you have this extreme amount as a penalty for liquidated damages.
sure,
If it's offset by the contractor can earn a bonus by the same amount per day by finishing early, the courts would look at that as an offsetting opportunity and would allow those extreme amounts.
I think that's a great argument. I am not aware of any Court of Appeals legal precedent or Supreme Court, state Supreme Court precedent saying that, but I think it's a great argument.
You know, flyover, for example, here was
Sure,
$5,000 a day, liquidated damages, unlimited
yeah,
per day. But then there was a bonus on the other side for $5,000 per day.
If you
limited-
finished early.
If you finished early
Sure.
for every day, up to 100 days.
yeah. I would probably try to use that scenario if I had to, or if I needed to, as an argument. And this is just further evidence that these amounts are very reasonable, because the owner agreed to reward the contractor that if he finished early, he got this bonus. And in a like amount, the contractor similarly agreed to be responsible. If he finished late, he would make it right with the owner. So what's unfair about that?
Yeah, and I think that's the argument I was reading, was basically they all.
That's a good point.
There's an opportunity to earn it and lose it at the same time.
I'm going to work that into the next time I do this.
Use the Santa Monica Freeway example too.
What was the LDs on that?
I think the oldies were 100,000, which
Yeah.
is applicable, and the bonus was $1 million a day. And to try and figure out what the damages might have been is, how do you figure that? You know, it's a big impact to LA, but
You
but
have
I-
traffic
I-
experts, you have traffic study experts about how, people, it takes longer for people to get to work, they have to take alternate routes, it takes more fuel, yada, yada, yada.
But I think, it was an impossible schedule, so they thought, no big deal. They'll never get this. If they do, it's great.
Right.
I think they beat it by maybe 10 days, something like that. So it was a
You
$10
know,
million
early
bonus.
10.
Yeah.
Early 10 days. I think there was, I think, now,
They get paid?
After a while.
I think there was
They
an early.
talked about it for a while, and then never.
I think there was an early completion bonus on portions of the DIA airport. Now, I don't know if that was terminals,
Yeah.
that's
Yeah.
been years ago. It might have been when they added some of those runways in.
Yeah.
I think there's maybe was some early completion. And, I mean, those would be big numbers because of the landing fees and the
It's
airport
worth it,
revenues. Oh,
But
sure.
it's hard to write the check.
Right. Anyway, further comments, questions on liquidated versus actual? It's a really important area. You won't spend a lot of time but you need to pay attention to it in your contract.
Just quickly, the amount too large voided as a penalty, unenforceable. It may not be enforceable, but there's probably still a claim, owner's claim, right?
Probably back to actual damages.
Right.
I mean, it doesn't, there again, you don't have to have, same rule, you don't have to have an actual damage clause to get, to make a claim for actual damages. And there's just assignment, so if you can't make a claim for liquidated, it's because it's void and unenforceable, then you move back to the actual damage claim. Okay. All right, now here's the one I thought we were going to next. I apologize, I'm hopping ahead of myself. Indemnification. When these come up, does anybody ever have a contract that doesn't have indemnity in it? Ever? And I think it's getting, I don't know the insurance guys in the room, I think the indemnity is getting more onerous. It's not getting any easier. People are getting more thorough, more complex, more riveting, whatever you want to call it. Okay, we're gonna have to read 3 slides. Everybody good?
Yeah.
Okay, this is what you're gonna stand good for. And some more stuff. Okay? More good stuff coming. Okay, I picked this indemnity clause because it's pretty thorough. It covers pretty much everything. It's like if you were doing a Christmas wish list, everything that you would maybe put on the list. If you want indemnity, not if you're given it, if you want it, it's pretty much here. But let's go through and explore some of this stuff. I have some points, but it's probably going to be more useful rather than look at the law according to Bob. Let's just go look at some of the, let's just go back to the language so it's in front of you. Whoops, I'm going the wrong way, sorry. Operator error. Okay. Anybody see any concern, big concern jumps off on this page?
Anytime you see the phrase any or all at the end of it, it's kind of a red flag.
Sure.
Defend.
Okay. Although most folks' insurance, whether it says defend or not, will provide, if on additional insured status, I mean, we're talking an additional insured claim here, will provide a defense anyway, correct?
Absolutely.
Yeah,
But
so
if you can get indemnify and hold harmless.
as the only undertakings, it just, less, you know the saying, sometimes less is more. It's, less is more here. How about lost profits, lost revenue, or profit disallowed? You okay with that? Want to sign up to that? Want to do that? Want to give them that? I don't either. It stinks. On top of that, what is profit disallowed? What is that? I don't know what that means. Fred?
Well, I don't think there's any such thing as a reasonable attorney's fee.
Now, here's the question I have. Does reasonable qualify attorney, or does it disqualify fee? Okay, you don't have to answer that.
I don't see anything.
Point well taken. I'm not going to add that into the settlement.
I don't see anything in here that limits it to the extent caused by the party as opposed to just everything.
Very good point. Very, very good point. There is a statute in Kansas, which we'll talk about a little bit, and that's what, since you've raised it, Jeremy?
Jared.
Jared, sorry. Since you've raised it, Jared, I'm going to go ahead and talk about it in a little bit, and you don't have to write this down, remember, just remember that it's out there. It's KSA 16-121, and it says indemnity in Kansas in a construction contract can only be given to the extent that the fault or the harm is caused by the party giving the indemnity. So if I'm indemnifying Jim for something I did, that's fine. But the Kansas statute says I'm not supposed to, or it's not legally allowable for me to indemnify something that Jim did. Because that's Jim. Why would I want to protect him from what he does wrong? I do it wrong, so that's what the statute says. Great point. How about How about number 1? Let's start out with the premise that to me, insurance and indemnity go hand in hand. If you indemnify somebody for something, you want, if at all possible, your insurance policy in place, whether it's yours, the named insured or primary insured, or additional insured status. Either way, both ways, you want the insurance to respond, correct? You want the insurance to step up. Hey, it ain't my money, it's the insurance company's money, but at least we got it in place. The indemnity's there, but the insurance. So personal injury and property damage, that's covered by a CGL. What's wrong with that? What's wrong with that language then?
Everything after.
Yeah, whatever kind.
Well, number 1, it doesn't say to the extent caused by me, and me only, or to the extent caused by me, and it doesn't reference the other key thing it doesn't do. It doesn't reference the concept of negligent conduct. Insurance coverage is triggered by negligent conduct, careless conduct. It is not triggered by breach of contract conduct. Now, the difficulty in construction many times is the two are they're kind of in the same glass of muddy water. Because if I breach the contract, well, you had to be negligent to breach the contract, didn't you? I mean, where does that vicious circle stop? It doesn't. But from a clarity of what we're undertaking standpoint, every time I can insert the word negligent in this kind of deal, the better off I think my client is. I'm assuming I'm representing the client that's giving the indemnity. So property damage or personal injury, including death, that's fine, of whatever kind or nature arising out of or as a result of or in connection with seller's negligence or to the extent of seller's negligence. Performance or failure to perform this PO, that's starting to sound like a breach of contract to me. And the last thing you want to do is have a contractor provision out there that puts you on the hook, but the insurance company is going to write you a letter and say we're either reserving our rights or we're denying coverage because we don't insure you, Mr. Insured, for your breach of contract failures. Same thing on number 2. That one's pretty straight. That one's pretty straight out. That's just a bad idea to agree to something like that. That's just not good. What about 3? My gosh. Is it lawful and enforceable? Is that a lawful provision if you sign the contract? Guess what? You're darn right it is. You're on the hook. I can't tell you some of these things I can tell you that's legally non-enforceable. Not that one. That is. You sign up to that. Here's my theory or my argument that I always use on 3. Hey, I have a contractual obligation to do that stuff anyway. Why do you want indemnity? Isn't that adding surplusage to what I've already given you? I'm already obligated contractually to my obligations, to my warranties, to my representations, to my certifications or guarantees. What is giving indemnity add to that? Get rid of that. That's usually that argument works more often than not. If it doesn't work, try to boil it back to a concept of negligent conduct rather than breach of contract. Comments on that? Four is kind of a troubling area because it's very common for owners to ask for that kind of indemnification for patent, intellectual trademark stuff. And it's pretty hard for a contractor to say carte blanche or blanket no. It's just not the way the world turns, okay? How I try to solve 4 is I try to say, if I, as the contractor, call for it, specify it, bring it on site, determine that it's needed, use it, because I decided to use it, I'll stand good for it. I'll stand for all that stuff. But if you, Mr. Owner, and your architect called for me to use this kind of widget that I had nothing to do choosing, don't ask me to indemnify you if widget company shows up with a case for patent infringement. That's not my deal, that's your deal. So I try to separate it that way. And I find that works. Do any of the insurance guys want to comment on insurance quickly? What kind of protection, if any, there is for insurance on that kind of thing? You guys want to?
Under GL, possibly under professional liability.
Yeah. That's what I was going to say. Under GL, probably Zippo. Under a professional, under a contractor's protected, possibly? Or under a,
CP, yes.
just a plain E&O policy?
Could be.
Right. But the rub comes is, how many of you GCs in the room, or subcontractors in the room, carry as a rule all the time a professional liability policy? Some do. Well, you're in that business though. So, interesting question. You can get left holding. So that's why I always try to, if I pick the pipe, I'll stand good for the pipe. If you pick the pipe, don't, and somebody has a problem with the intellectual property aspects of the pipe, don't come knocking on my door. 5. I am seeing a little bit less of 5, the sole negligence, where the contractor is being asked to indemnify for the owner's sole negligence. I'm seeing less of that, mostly because states, whether legislatively or case law, are starting to nix it. But you've got to watch out for it, because in states where, like Texas, for example, if it's legal or permissible to do it, if you do it right, it's enforceable. And if you get into one of those, it's bad. Because you know what? I have a hard enough time controlling myself. I can never control Mr. Jim Renner, even though I'm not trying.
We just saw a city of McKinney, Texas, bid proposal. The indemnity language caused the contractor to accept all the political or the elected officials' negligence, whether related to the job or not.
Oh my gosh.
And of course, we pushed back, and our contractor said, hey, remove that provision and I'll stay on the bid list, and they wouldn't. And six contractors
Stayed on.
did that project. And the elected officials, the way that it was written, actions did not have to even be relevant to the project for the indemnity.
Is that even in any way an insurable
No.
risk? I didn't think so. I mean,
But legal in Texas.
the legal in Texas to do. Absolutely. Texas is probably one of the last remaining pure, almost pure freedom of contract rules government. Whatever, if you're big enough to, if you're big enough to pick up a pen and sign it, you're deemed to be big enough to read it. And if you're big enough to read it, you're big enough to understand it or pay some very reasonable legal fees to get you to understand what it means. Okay? All right.
So in Kansas, or all three forms, you have limited, intermediate, and broad form.
Right.
Are all three enforceable in the state of Kansas?
I have seen some broad form. Well, you're talking about the insurance side, or are you talking about the indemnity?
The indemnity side.
There are. I've seen what I would call broad form class language drafts that I think the better argument is they run afoul of that 16.121 than they do not. So I can't say there again. Like every question you most times ask me, the answer is going to be it depends.
Joe, if they can carve it outside of the construction contract, such as a material supply, a trucking, anything like that, then the indemnity statute
Doesn't apply. Yeah.
So they could get the broad.
Yeah, there is no general broad prohibition against sole and broad form indemnity in Kansas, other than the statute.
And from an insurance standpoint then, how often do you have to provide insurance for a broad form indemnity requirement?
bodily injury, property damage, personal injury.
That's it.
That's it,
Okay.
for your negligent act.
And if the contractor is signing that, they're on the hook.
The balance sheet now becomes the.
That's right.
I'm
I
gonna
try to
take,
explain that in contracts.
Yeah, right.
I'm gonna take about 2 more minutes. We've got 2 sections and I'm gonna talk about them. The one is pretty quick. That's this language, this clause on mechanics liens. These still are running around all the time. I see them all the time, where a clause in a contract says that the contractor agrees to waive and release its right to assert a mechanics lien. You cannot do that under Kansas law. The Kansas Fairness in Private Construction Contract Act says you can't do it for liens. The Fairness in Public Construction Contract says you can't do it for bond claims. You can't do it, you can't do it, you can't do it. It could be in a contract. Guess what it's worth? Zippo, zero, zilch. It is not enforceable. The one thing, it's a sticky area. It's easy to understand, but a lot of people don't. And that's that in both the acts, both the public and private acts, the public and private acts allow for partial lien waivers and releases on progress payments.
That was gonna be my question.
But it's only, you can only do those to the extent of the progress payment received, period.
Right.
If you try to get a if you try to get a, if an owner tries to get a contractor, or if a contractor tries to get a sub to release all of their rights for everything at any and all times, no matter what happened or when it occurred, and they only pay them for that payout, it's their rights are only waived up to that dollar amount. So it's a pretty great provision in the law, as far as I'm concerned. A lot of people don't know that, and they don't know how to work that. That's a great provision of a lot of benefit to contractors and subs and suppliers in the state of Kansas. Okay, last thing. This is a watch out for. Since December 1st, I have seen 3 documents that have come across my desk that say purchase order. They're long, lengthy, hard to read, give even me a headache to read them. They're designed, they're tried, true, tested forms, but they're purchase order forms of big manufacturing companies. For example, the aircraft companies here in Wichita have these forms. They use them to buy pieces and parts in the manufacture of their airplanes. Seat parts, the steering wheel parts, the engine part, whatever they buy in use of, they use these to buy commercial goods. And now that the economy has gotten a little bit ticked up, and some of these companies, this one happens to be Hee Haw Corp, and the project manager is Junior Samples. Anybody remember him? His phone number was BR549. This is Junior's your rep, and he said, "Hey, we got a little over $1.5 million. We were gonna redo our lobby and make it look great. We have some money to spend on the building for a change. But in order to do the job, in order to get authorization and not buck the higher ups and not create too many red flags, I have to use this form because this will sail through the accounting people. They'll just see it and they'll stamp it, and we'll be off to the races." Well, guess what? And I just copied a few. And you want to call it boilerplate or fine print? Oh my God, understatement of the year. This goes on for like 20 or 30 sections of stuff like this. And these are good terms, but they relate to the purchase of seatbelts for an airplane, or the windows that go in, not for construction work. And so we have a whole document that doesn't apply. And somebody will send one of these to me and they'll say, "Can we make this work?" And I say the best thing to make it work is tear it up, throw it in the fireplace, and tell them, suggest that you use an AIA document or consensus doc or a real construction contract. We don't. One of them went back and started to try to take one of these forms and penciled it up to the least extent possible. Guess what happened? The project got killed. Well, is that a good thing or a bad thing? I don't know. But what happens if it gets signed and then there is a squabble and you got a contract, the shoe, I call it the shoe doesn't fit. Be on guard. There's a lot of that happening. Like I say, since December 1st, I've seen 3 of them. And these are not just fell off the truck, turnip truck companies. These are sophisticated companies. Sorry, I ran a little bit over. That's words of wisdom for today. Anyone, questions, comments?
So were you able to negotiate these things to?
One of them.
completion?
One of them. The other 2. Thank you very much.
Thank you.